Well, I haven't done one of these in a while. I was doing them in the backyard in the nice weather, but it's February and a little too chilly for the outdoor videos. Today I'm going to talk about 341 meetings or creditor meetings. 341, Section 341 of the Bankruptcy Code says that everybody gets a chance to come and ask you questions if you file bankruptcy, whether you're a company or an individual. We call it a court date, but there's no judge there. The trustees that's appointed to your case presides over the hearing. What is the purpose? Nothing is decided. There's no judge there, no one with any authority to make any decisions on your case. But you have to be available in case creditors want to come and ask questions about your finances, your assets, your liabilities. It doesn't happen in Detroit anymore, except that the credit unions have attorneys who are usually there, and the auto finance companies, Chrysler, Ford Credit, or Alley Financial might have someone there. Otherwise, it's the exception rather than the rule. But it's still called a creditor's meeting. They don't have to go. You have to go. Your attorney has to be there. You're the one who's sworn in under penalty of perjury, as when you sign the papers, under penalty of perjury. So this is a chance to make any corrections, something that you forgot, that slipped your mind when you filled out your papers. You need to bring it up at that time. There's only 3, 4, 5 minutes. Maybe the trustee will let it run longer, but hearings are scheduled every half hour right now in Detroit, so there's not a lot of time for each individual case. Many of the trustees in Detroit have their own questionnaire that you fill out before the hearing, so you want to be there at least a half hour early. That's what I tell my clients. They do not use the same questionnaire. Some do, some don't. And of course, they're free to change them whenever they want. So I'm not sure ahead of time which questionnaire which trustee will be using. And basically it repeats information that you've already put in the schedules, but we want to make the trustees happy and get this hearing over with. Many of the documents that you provide me or your attorney ahead of time, tax returns, pay stubs, vehicle titles, recorded real estate documents, things like that, we have to provide to the trustee ahead of time. Because doing 7, 8 cases every half hour, they don't have time to read through all those things while there's a room full of people waiting for their case to be heard. So on the website I've got a link where I'll upload the suggested questions. I've got the link to the U.S. Trustee Handbook. Each of them has a little different style in how they ask their questions based on their experience as trustees over how to elicit information that they want that might have been left off or that they can't quite understand depending how the schedules are filled out. I try to be very thorough. I like to have everything apparent just from the documents, that if you look at the documents, the trustee or anyone else can tell what's going on with the property and what the debts are, what exemptions we're claiming, because we want the trustee to deal with the case, close it up as a no-asset case, and move on, unless you have assets that aren't exempt. Check out the exemption video for questions on that. So, if you have 7 or 8 hearings, I don't know if we're first or last till we get there. Sometimes the trustees may be backed up, so you might have an 11 a.m. hearing, but if they got backed up with something they spent a lot of time on, maybe it's 11:30 or noon before you get called. Some trustees are faster than others in terms of the questioning. We'll see how that goes when we get there, but most of the creditors who want to deal with your case will hear from ahead of time. A car creditor may be there, but the mortgage companies, if you're keeping your house, they have your house. They're getting the payments. They don't have to come and ask questions. It's lost money for the creditor for them to pay somebody to show up and ask you questions. If they want to go on the court website, they can look at all 30, 40 pages of your budget and income and expenses and assets. The trustees are there to investigate to see if you have any assets that can be liquidated, sold for the benefit of creditors. So the creditors, mostly in the United States, have made a business decision not to throw good money after bad and not to pay someone to show up or to pursue even accounts that are listed in a bankruptcy case. So I hope that answers many of the questions. Let me know if you have more that you would like answered, and we will talk next time. Kurt O'Keefe, Detroit Bankruptcy Lawyer.